legal quandary created in the wake of a number of Attorney General opinions that have been issued on this legislative effort. Many, many years ago, the American Planning Association adopted a model ordinance, which has been the model for almost every community in the state of Florida, probably almost nationwide. And the adoption of the model ordinance speaks in terms of what are permitted uses. Every zoning ordinance that I'm aware of, with some exception, makes a list of what are called permitted uses. And if it's not on the list, it's not permitted. Pinellas County's zoning ordinance is that way. I would venture to say that the vast majority of municipalities and counties in the state of Florida have lists of permitted uses, and if it's not on the list, it's not permitted. The assumption has always been that if vacation rentals are not on the list, it's not a permitted use. The Attorney General, however, twice now has issued an opinion to the effect that if you didn't specifically prohibit it, which is not the way zoning ordinances are written, then it doesn't qualify for the grandfather. So that's the quandary that Pinellas County and many of the other municipalities are in with respect to the validity of their zoning ordinances. So with that as a background, I can speak to you a little bit about what I'm aware of. I know that the city of Clearwater, I believe, has an ordinance that strictly prohibits vacation rentals. I just spoke this morning with a representative, city attorney for Tarpon Springs, who indicated some years ago they effectively defended their ordinance. But that was prior to the legislation. I don't know whether it would still be effective in the face of this legislation. So what has happened is most municipalities thought all along that their list of permitted uses prohibited it, and the Attorney General said not good enough. So that interpretation has had communities like the unincorporated area of Pinellas, and I believe the city of St. Petersburg also has taken steps to deal with what we often call the secondary effects of those rentals. That is on-site parking issues, noise, not duration of occupancy, but the number of people who can occupy a facility, those sorts of things. We have a representative here from Pinellas County. Renee Denson is here, and we wish to hear what our draft regulations are looking like. We have yet to actually go to court and call into question the validity of the Attorney General's opinion with regard to our ordinance. But we don't have a significant problem in the unincorporated area of the county. I think that the primary issue is those beach communities with these vacation rentals are quite attractive. I think that the bulk of the complaint that you would hear from those municipalities would be in those areas where that sort of vacation would be most attractive. We've had some issues up in Palm Harbor and Crystal Beach, I believe, which is the Pinellas County's weak equivalent of a waterfront arena. But the bulk of the problems that I've heard of have been in the unincorporated beach communities. The incorporated beach communities.
Okay, let me ask you specifically. I believe I know the answer, but I just want to get this on the record. Would a local bill on this issue applying only to Pinellas County or only to one city in Pinellas County, would it override the existing statute?
I think you would have to depend on your lawyers in Tallahassee, but I think there's a prohibition against that type of special local bill that is that targeted.
Okay. Do you have any suggestions? And you and I talked about this, and I told you I was going to ask you for suggestions. Do you have any suggestions of how we can deal with it?
I'm hearkening to the comments made by Representative Sprouse about the legal glitch associated with what happened in the Reading scenario. Like I said, most of the municipalities and counties in Pinellas County adopted the prohibited, the permitted use approach to things. A legislative blessing of that type of an approach would resolve a lot of the problems. But obviously I'm in a bit of a conflicted position in the sense that a representative community would love that to happen. That you could draft a provision that would say that if they are not permitted in an area, they are not allowed. I don't think that speaking, I think to, I think it was Representative Grandis who talked about, Senator Grandis was talking about the property rights issue. I think in most communities there has not been a legal expectation that these are permitted uses, and it's been a pushing of the envelope. So whether or not there's a reasonable expectation that somebody should be able to establish these uses in areas that are regulated by zoning ordinance that do not permit them, I think that there's a real question whether there's a property rights issue there at all. They have been established in the face of community regulation to the contrary. But that's perhaps a little editorializing on my part.
If we were to change the state statute at this point, basically outlawing the places that are using this now, or that is being done now, we would risk having a taking under the Burke-Harris Act, which they would then have to be compensated. Is that not correct?
There is that potential, but like I said before, the question is whether or not under zoning ordinances, absent the Attorney General opinions, I would say that there was never a reasonable expectation. In the words of Bert Harris, this would not be a reasonable, non-speculative use, which is the type of use that is protected under Bert Harris. I think it's speculation on the part of individuals that they are going to be allowed to use these properties for these purposes under existing zoning laws. So, yes, there's always a risk.
Okay, one last question. A bill that could be brought forward that says something to the effect of any community with an ordinance in effect on such and such a date, 2011, whose ordinance was ruled to be invalid after that, has a period of a year to fix it on this issue. Would that be a potential approach?
That would solve extremely limited numbers. I think it would probably address the Reddington issue, but it does not address the vast majority of those areas that have the American Planning Association approach to zoning that had permitted use.
Well, I've asked you, and I've asked the audience. We've got three other beach mayors here, and only have heard one city. Now, they're all here supporting their colleague, but I haven't heard that any other city in Pinellas has a problem, other than generally they want home rule, but they've got ordinances in place. I made sure myself personally in 2011 that Clearwater was covered, okay? Because, they were in the mix. I represented Clearwater, and they had an ordinance, and they want to make sure it's covered. So we made sure of that. But we've got one problem city and I guess, let me put it this way. Speak now or forever hold your peace. Is there a substantial problem in Pinellas County in another city other than Maryland? RB?
You need Rock's Beach.
Okay, come up here and tell us what your problem is.